Good morning, everyone. Welcome to this lecture series on the rules on evidence. This morning, we will discuss Rule 130. So let me share my screen with you. Rule 130. Rule 130 class talks about the rules of admissibility. Now, this provides for what are the standards required before an evidence is admitted by the court. So first, let us go to the different classifications of evidence. First, you have object or real evidence. This is also known as demonstrative evidence. Autoptic preference and physical evidence is the evidence which is addressed to the senses of the court. So this is the definition of what an object evidence is. When you say object evidence, this evidence is addressed to the senses of the court. When you say senses, it extends to the visual, auditory, tactile, gustatory, olfactory, and is considered by the rules of court as the evidence of the highest order. Now, so there you go. So an object evidence is the one which is addressed to the senses of the court. Now, since the evidence is addressed to the senses of the court, the rules of court consider it as the evidence of the highest order. Okay. Now, let us go to authentication of object evidence. Now, what do you mean when you say authentication? You will encounter this, in practice. No, evidence are authenticated. And what and why is the evidence authenticated? The evidence is authenticated in order to avoid the introduction or presentation of an object evidence which is different from the one testified about. So for example, the police officer will present the knife that was used in the killing of the victim. When you say authentication of evidence, that means that the witness will testify that the one being presented in court is the one that he was talking about when he executed his sworn affidavit. So you have to establish the identity of the object. In other words, that object referred to in your testimony is the one that was actually being introduced in court. Now, authentication of object evidence is also to ensure that there has been no significant change in the object's condition. This is also in order to establish that the evidence is the same kind and quality, at least for the purpose of the testimony. This is the same evidence that was obtained from the scene of the crime, and this is the same evidence that was being referred to during testimony, and this evidence is being the one referred to when it was or when it is to be presented in court. Now, what are the requirements before an evidence is admitted in court? In other words, what are the requisites for admissibility? First, it must be relevant to the fact in issue. Second, it must be authenticated before it is admitted in evidence. It must not be hearsay. It must not be covered by any privileged communication, and it must meet any additional requirements set forth by law. Now, what does object evidence include? It includes any article or object which may be known or perceived by the use of the senses. It can refer to examination of the anatomy of a person or of any substance taken therefrom. Third, it can refer to conduct of tests, demonstrations, or experiments. And fourth, examination of representative portrayals of the object in question, such as maps and diagrams. So these are the different compositions or different kinds of object evidence. Any article or object, examination of anatomy of a person, test demonstrations, or representative portrayals of the object like maps and diagrams. Now, there are different kinds or categories of object evidence. First, you have unique objects. When you say unique objects, this refers to those evidence that have readily identifiable marks. So, for example, a gun. Now, it is a unique object because a gun would consist of the specification and the serial number. So since there is a serial number, it is readily identifiable from the rest. Now, second is objects made unique. What do you mean by objects made unique? This refers to evidence that are readily identifiable. Example, a bolo knife used to hack a victim, which could be identified by a witness in court. So when you say objects made unique, this is formerly or previously not readily identifiable, but because there is a testimony of a witness, then it subsequently becomes readily identifiable. Okay, so objects made unique, kanina, unique objects. When you say unique object, it is already identifiable by and itself. When you say objects made unique, it could only be readily identifiable upon testimony of the victim. You have here non-unique objects. These are those which have no identifiable and identifying marks and cannot be marked, such as footprints left at the crime scene, fingerprints, or for example, blood samples. Now, these have no identifying marks. No? Now, let us compare between real or object evidence and demonstrative evidence. First, an object evidence is tangible. Now, it can be touched. It is tangible. Object that played some actual role in the matter that gave rise to the litigation. Whereas demonstrative evidence is tangible evidence that merely illustrates a matter of importance in the litigation. So demonstrative is more of pointing, while object evidence is the actual object. Now, real evidence intends to prove that the object is used in the underlying event. Demonstrative evidence intends to show that the demonstrative object fairly represents or illustrates what is alleged to be illustrated. Now, sometimes if the prosecution will present evidence, the evidence could not be brought inside the courtroom simply because, for example, the object evidence consists of the crime scene, the house, which is by nature immovable property, or for example, even if it is movable, but it could not be brought to the court because it was wrecked, especially in cases of reckless imprudence resulting to damage to property. That vehicle which was wrecked cannot be brought to court for obvious reasons. And therefore, what the court can do in order to view that object or scene of the crime is what you call as ocular inspection or view. An ocular inspection conducted by the judge without the presence of the parties or without due notice is not valid. An ocular inspection is part of the trial. So, class, the judge may not by himself go to the scene of the crime or the crime scene or to the object which is presented as evidence. No, he cannot do that without the participation of the parties. Ocular inspection is always done after notice and with the presence of the opposing parties, the prosecution and the defense. Take note that it is a mere discretionary act of the trial court to go to the place where the object is located when the object evidence cannot be brought in courts. So, class, you cannot compel, you cannot oblige, you cannot force, you cannot demand as a matter of right that the court will go outside the courtroom and inspect or view the object or scene because the ocular inspection is subject to the wise discretion of the court, meaning the court can decide or the court may or may not conduct the ocular inspection. So it is a matter of choice or discretion on the part of the court. Now, you will take note that under Republic Act 9165, no, under Section 21 thereof, there you have a chain of custody. Ano ba yung chain of custody, class? Ang chain of custody is, kaya tinawag siyang chain because there are interlapping or loops of custody of the evidence. For example, from the time that the evidence was recovered from the accused up to the time that there was some form of inventory of the drugs taken from the accused, up to the time that the drugs obtained from the accused is brought to the PNP crime laboratory for confirmatory tests, up to the time that the drugs is brought to the court for presentation of evidence. So this is the chain of custody as observed in drug operations. What is the purpose or why do you need to establish chain of custody in drug cases? Chain of custody under Section 21 class is a very, very important concept in RA 9165. Chain of custody is a method of authenticating the evidence. Again, chain of custody under Section 21 is a method of authentication of evidence. If you violate the requirements under Section 21, the Supreme Court said that the accused is entitled to an acquittal. Why? Because again, the purpose of authentication is to establish that the evidence being presented in court is the same evidence that was obtained during the time that the evidence was recovered from the accused. You have to establish that this is the same evidence, the same object evidence obtained during operation and that which is presented in court. So without authentication or for failure of authentication, the accused will be entitled to an acquittal. Now, it requires that the admission of an exhibit be preceded by evidence sufficient to support a finding that the matter in question is what the proponent claims it to be. Now, what are the purposes of establishing a chain of custody? Why do you need to establish a chain of custody? This is to guarantee the integrity of the physical evidence. You are talking about crystalline substance. These could be sugar, this could be uh, any other materials, which is powdery, which is pretty much similar to methamphetamine hydrochloride. So the chain of custody is to guarantee, to ensure the integrity of the physical evidence. This is to ensure that there is no intercalation of the evidence. This is also to prevent the introduction of evidence which is not authentic. An evidence which is not authentic refers to an evidence which has been substituted or intercalated. This is prohibited. As a matter of fact, under RA 9165, planting of evidence is punishable by death. Okay, and since there is no death penalty, then life imprisonment. Huh? So chain of custody is for the purpose of preventing the introduction of an evidence which is not authentic, but where the exhibit is positively identified. The chain of custody of physical evidence is irrelevant. So again, but where exhibit is positively identified, the chain of custody, then the physical evidence is irrelevant. Now, let us go to rule on DNA evidence. Now, the rule on DNA evidence, AM number 06-11-5-SC Supreme Court. It applies whenever DNA evidence is offered, used, or proposed to be offered or used, as well as evidence in all criminal and civil actions, as well as special proceedings. So DNA evidence, usually this can be used in rape cases where the presence of semen specimen is found in the private organ or the reproductive organ of the victim, and then there will be some DNA testing to know if the DNA samples found will match the DNA of the accused. So if in case that DNA evidence will be used in court, then you apply the rules on DNA evidence. What is DNA? DNA, or deoxyribonucleic acid, is the chain of molecules found in every nucleated cell of the body. DNA evidence constitutes the totality of DNA profiles, results, and other genetic information directly generated from DNA testing of biological samples. DNA testing means this is a very long paragraph, but when you say DNA testing, this is identification, or this pertains to analysis of the biological samples that originate from related persons. Now, what are the requisites for issuance of a DNA testing order? Number one, a biological sample exists that is relevant to the case. This is the very first requirement. For example, in a rape case where the private complainant alleged that there was no ejaculation. If there is no ejaculation, then there can be no biological sample, or there might be no biological sample. Because in rape cases, the mere touching of the labia majora or majora and an erectile penis will consummate rape. So in case that there is no DNA sample, there is no biological sample, then you cannot call for a DNA testing. Number two, biological sample was not previously subjected to the type of DNA testing now requested, or that it was previously subjected to DNA testing, but the results may require confirmation for good reasons. Third, the DNA testing uses a scientifically valid technique. Fourth, the DNA testing has the scientific potential to produce new information that is relevant to the proper resolution of the case. And number five, the existence of other factors, if any, which the court may consider as potentially affecting the accuracy or integrity of the DNA testing. So we're done with object evidence. We go to documentary evidence. What is a document? Document is an evidence consists of writings or any material containing letters, words, numbers, figures, symbols, or other modes of written expressions offered as proof of their contents. Okay, what are the requisites for admissibility of documentary evidence? The document must be relevant. The evidence must be authenticated. The document must be authenticated by a competent witness. And fourth, the document must be formally offered in evidence. What is the best evidence rule? Best evidence rule provides that when the subject of the inquiry is are the contents of the document, then no evidence shall be admissible other than the original itself. So as a general rule, the original document must be produced in court subject to certain exceptions. You have to memorize these exceptions. First, when the original has been lost or destroyed or cannot be produced in court without bad faith on the part of the offerer. Second, when the original is in the custody or under the control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice. When the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the fact sought to be established from them is only the general result of the whole. And when the original is a public record in the custody of a public officer or is recorded in public office. So, three concepts of original document. Number one, the original of the document is one, the contents of which are the subject of inquiry. So class, you only apply the rules on best evidence rule or the original document rule when the contents are the subject of the inquiry. If, for example, the subject of inquiry or the issues in fact in court is not or are not the contents, but the mere existence, for example, or the color of the document, then you do not apply the rules on best evidence rule. No? When a document is in two or more copies executed at or about the same time with identical contents, all such copies are equally regarded as originals. Third, when an entry is repeated in the regular course of business, one being copied from another at or near at the time of the transaction, all the entries are likewise equally regarded as original. Now, class, if the original evidence cannot be presented, then you can resort to secondary evidence. Secondary evidence is that which shows that better or primary evidence exists as to the proof of the fact in question. It is the class of evidence that is relevant to the fact in issue. It being first shown that the primary evidence or the original evidence of the fact is not obtainable, it performs the same functions as that of a primary evidence. Okay. So as a general rule, all originals must be first accounted for before one can resort to secondary evidence. It must appear that all of them have been lost or destroyed or cannot be produced in court. This is the only time that you will be allowed to resort to secondary evidence. Now, again, take note that all originals must be accounted for and that all of them cannot be produced in court. Now, secondary evidence may be admitted when, first, the offerer must prove the due execution and existence of the original. Second, the offerer must show the cause of its unavailability. And third, the offerer must show that the unavailability is not due to his bad faith. Now, order of presentation of secondary evidence, you have to establish copy of the original, or if it does not exist, a recital of the contents of the document in some authentic document. So for example, a board resolution, sometimes the contents of a board resolution is also reproduced in the corporate in the secretary certificate, for example. So these are recitals of the contents of a document in some other authentic document. So that secretary certificate is, or SecCert is what? Contains a recital of the contents of the board resolution, and therefore it could be considered as a secondary evidence. Third, by testimony of witnesses. So you can prove the document by testimony. So first, copy of the original. Second, recital of the contents in some other authentic document. And third, by testimony of witness. Let us go to definite evidentiary rule. Okay, where the law specifically provides for the class and quantum of secondary evidence to establish the contents of a document or bar secondary evidence of lost document, such requirement is controlling. For example, the evidence of a lost notarial will should consist of a testimony of at least two credible witnesses who can clearly and distinctly establish its content. So under the rules of court, if notarized last will and testament is lost, then it can only be established by testimony of at least two credible witnesses. These two credible witnesses are the instrumental witnesses in the notarial will. All other witnesses are not qualified to testify as to its contents. Now, when the original document has been lost or destroyed or cannot be produced in court, the offerer, upon proof of its execution or existence and the cause of its unavailability without bad faith on his part, may prove its contents by a copy, 1, recital of its contents in some authentic document, 2, or by testimony of witnesses in the order stated. Okay? Now, when the original document is in the control and possession of the opposing party, then the party who seeks to introduce that document may give notice to the opposing party to produce the document. If after such notice and after satisfactory proof of its existence, the opposing party fails to produce the document, then secondary evidence may be presented as in the case of its loss. What are the facts that must be shown by the party offering secondary evidence if the original is in the custody of the other party? First, original is in the possession or under the control of the opponent. Second, there is demand or notice that is made to him by the proponent signifying that the document is needed. Third, there was refusal or failure of the opponent to produce the document in court. And fourth, there is a satisfactory proof of existence of the document. Take note that the party who called for a document is not obliged to offer it into evidence. Okay, what if the evidence or the original document is a public record? When the original of document is in the custody of a public officer or is recorded in a public office, its contents may be proved by a certified copy issued by the public office in custody thereof and an official publication. So this ends our discussion on part 1 of Rule 130. I'll see you again next meeting. Thank you.